Okay, folks, can I have quiet, please? Hello? Quiet, please. I am literally doing this with, I have a couple of little notes here, but I'm doing this off the top of my head because I know the stuff. I don't need much of my notes, but my previous version of my Torts intro was 50 minutes. I've been making newer intros that are longer than my originals, but I don't want to replace the Barbary lectures with, so I'm trying to, somewhere in between, right? I'm trying to give you an overview that will help focus your reading, hitting major points and telling you what's really important, okay? So, we were done with duty. The first big issue in negligence is there a duty? How do we set the standard of care? Interestingly, the second element, breach, is not much to say. It's, did the defendant violate that duty, whatever it is? Generally a jury question, a fact. One specialized doctrine, res ipsa loquitur, which is not English, it's Latin. The thing speaks for itself. And all it means is circumstantial evidence to prove the breach. Caveat: for whatever reasons, the phrase negligence per se and res ipsa loquitur mean totally different things, but people confuse them all the time. Negligence per se is the name of the doctrine we use where there's a statute that if the judge finds that plaintiff class of risk, then he'll instruct the jury that the statute sets the standard of care. Res ipsa loquitur is not setting the standard of care. It's talking about how the plaintiff can go about proving the breach in a situation where the plaintiff doesn't know what happened. I'm walking along the street, something hits me on the head, I'm carted off to the hospital. I don't know what happened. My lawyer goes to find out. Lawyer can't find out what happened except something came out from a second-story window and splattered me on the head and left me unconscious, but I recovered, but whatever. Okay. Or I died, whatever. How can the plaintiff prove that the defendant was negligent if the defendant doesn't know what the defendant did and the defendant is not willing to get on the stand and say, yeah, I was negligent? Well, the courts say circumstantial evidence can be used to prove breach even if there's no direct evidence sometimes. But what do we need to have? What must the plaintiff show for the jury to be able to make that inference of negligence where there's no direct evidence? Must show that the kind of thing that happened is something that doesn't usually happen unless somebody was negligent. Flour barrels don't usually go rolling out of a window and hitting people on the head on the sidewalk unless somebody was careless. If you're going to push something out the window, you ought to look and make sure nobody's down below to be hit, right? If you're rolling a flour barrel and there's a nearby place where it might fall, you ought to make sure it doesn't fall. So it wouldn't usually happen unless somebody was negligent. And basically the only people there who could have done it were either the defendant himself or his employees or agents. So the defendant has to be responsible, or we can infer the defendant was responsible because nobody else was there. In which case, the jury may, emphasize may, not must, may infer negligence. Okay? The other thing to be emphasized with res ipsa is its procedural significance. You all had civil procedure. You all know that there is such a thing as a motion for a directed verdict, as it used to be known, or a motion for a judgment as a matter of law in modern terminology, meaning the defendant says at the end of the plaintiff's evidence, plaintiff didn't have any evidence on one of the elements it needed to prove, therefore it shouldn't ever get to the jury. We don't want to get to the jury because the jury's liable to find for the plaintiff. Your Honor, the prima facie case is the elements that the plaintiff must prove. The plaintiff offered no evidence that I did anything wrong, that I breached. Res ipsa is a way to get to the jury if the judge is persuaded that we are in a res ipsa kind of situation, kind of thing doesn't usually happen unless somebody was negligent, defendant was in control, then the judge will deny a motion for a directed verdict made by the defendant and say, there's enough evidence for a jury to possibly infer that the defendant was negligent. That's all. It's used to overcome a motion for a directed verdict, to get to the jury. And does not mean that you, ladies and gentlemen of the jury, must find negligence. Means you, ladies and gentlemen of the jury, may find negligence. It's up to you. If the jury comes back with a verdict in favor of the defendant because they do not infer negligence, breach, plaintiff loses, judge is not going to give a judgment notwithstanding the verdict or judgment as a matter of law against the jury, because it's just a matter of you get to the jury, not that the jury must find. This is tested on every exam at least several times, right? Always tested on MBE, often an issue in essays. Breach. Cause and fact. Now, the way Barbary has laid it out, it's like causation altogether, legal causation, subdivided then into actual cause and proximate cause. And it's easier, I think, just to say cause and fact or actual cause is one, and proximate or what used to be called legal cause as the other. Cause and fact is a factual question. And the most common test you all heard is the but for. But for what the defendant did, the plaintiff would not have been injured. The but for test. Sometimes the substantial factor, a number of things came together, but the defendant's behavior was a substantial factor. But it's a question of fact, basically, of what happened. Interesting set of issues that comes up here is where there are multiple actors, and sometimes we're not sure which actor was the one who actually caused it. We might have enterprise liability. Hey, everybody who's engaged in the enterprise of selling this stuff will be liable according to their market share. Plaintiff doesn't have to prove, well, this one or this one, which one actually caused his injury. The whole industry is liable. Or two people shot and person got hit by one bullet, we can't prove which one. We shift the burden to the two defendants. Hey, you're both liable unless you can prove that it was the other guy. So those kind of multiple defendant problems often come up for a question on the MBE. But that's about it for cause and fact, not a big issue generally. Proximate or legal cause. Now, interestingly, the third restatement of torts, which I assume you all have on your bedside table and have been reading, says we are not going to use that phrase anymore. We're not going to use proximate cause. We're not going to use legal cause. We are going to replace it with the concept of scope of liability. Yeah. What's the difference? The question is, assuming the defendant had a duty, breached the duty, and that breach actually caused an injury, does this tort cover all possible injuries, or are there some limitations on the scope of liability? This has traditionally been labeled as proximate cause. Give you my favorite example. I'm out in the parking lot. I'm backing up my car. I negligently run over Marty Margulies' toe. Ambulance comes to take Marty to the hospital. Ambulance driver driving to the hospital negligently gets involved in an accident, causing some further injury to poor Professor Margulies, who then arrives at the hospital, taken to the emergency room, wheel him in for a little operation on his toe. Doctor commits malpractice and causes further injuries to Professor Margulies. Margulies is taken to the recovery room. Charlie Manson, who has escaped from prison in California, has come to the East, stolen an Uzi, comes into the hospital emergency room and just shoots the place up. A bullet causes some further injury to Marty. What's the scope of my liability? I'm liable for the original injury. I'm liable for the injury from the ambulance driver because rescuers are foreseeable and they can cause further injuries. I'm liable for the injuries caused by the medical malpractice trying to fix him because that's how lawyers make a living. No, because medical malpractice trying to fix an injury is said to be perfectly foreseeable. It's the kind of risk you created. It's within the scope of liability. It's within proximate cause. Marty being shot by Charlie Manson. Well, but for Marty being in the hospital, he wouldn't have been there when Charlie shot it up. But Charlie Manson shooting up a hospital is not the kind of injury that anybody could have foreseen as a result of my running over poor Marty's toe. So I'm not responsible. That's outside of the scope of my liability. When there is a later act of a third person that is unforeseeable, then it is a superseding, wonderful term, cause, and only Charlie is liable for the portion of injury that is attributable to his behavior. My liability does not extend to the further injury, if any, caused by Charlie Manson. That's the kind of thing we're talking about mostly with proximate cause. See all the examples in Barbry's outline, but particularly you will see examples as we go through cases of what is within that scope of liability and what's not, and that's often tested. Finally, we get to damages. Damages are absolutely a requirement for negligence. It's not most of the intentional torts not necessary. In negligence, it's an element of the prima facie case. Have to prove injury to the person, actual bodily injury, or injury to the property, actual property injury, or when negligent infliction will do, you have to prove actual emotional distress. No damages, no tort. If you don't have all of these elements, no tort, right? Every one of them. Defenses. Oh, little cross-reference. If the injury caused by someone's negligent behavior is an injury to someone's business use of his real estate, negligence doesn't cover it. But nuisance may, right? Defenses. When I went to law school, the big defense in negligence was what is called contributory negligence. If the defendant could prove that the plaintiff had done something unreasonable that had contributed to his injury, that was a complete defense and the plaintiff lost. But there were some saving doctrines if the plaintiff could then prove, yeah, okay, I was contributorily negligent, or assuming I was contributorily negligent, the defendant still had the last clear chance to avoid this. After my negligence, defendant did something later. Those were the rules that we worked with when I went to law school. But I remember in the case book, there was a little thing about some really freaky states, I believe Wisconsin, Minnesota, somewhere out there, trying this new thing called comparative negligence, which has now pretty much swept the country. So on the bar exam, it's comparative negligence, unless they tell you that you're in an old-fashioned contributory negligence jurisdiction, which is getting less and less likely, but they can, right? So as long as they don't tell you that you're in a comparative negligence, an old-fashioned contributory negligence jurisdiction, the rule is going to be one of comparative negligence, which means if the defendant proves that the plaintiff contributed by his negligent behavior to some degree in his own injury, that's not a complete defense. It only will reduce the amount that the plaintiff can collect. In what is called a pure comparative negligence jurisdiction, it doesn't matter if the plaintiff was 80% at fault and the defendant 20%, plaintiff can collect the 20%. In partial comparative negligence states, if the plaintiff was as much at fault or a little more at fault than the defendant, In those cases, the plaintiff may not be able to collect. So it depends on the kind of comparative negligence. See the discussion again in the Barbary outline. Contributory negligence is not the term we would use if one defendant says, well, the other defendant was negligent too. Contributory negligence refers to the negligence of the plaintiff on the particular claim. The defendant says, plaintiff's negligence contributed to this, so he was contributorily negligent. If it's one defendant saying, well, maybe I was negligent, this other guy also was negligent, we don't call that contributory negligence, it's just negligence. But we do, maybe the reason it's confusing is we can allow for contribution between defendants. We'll see that much later. Okay, just a matter of language. Strict liability. So we've done intentional torts, negligence, which is the biggie, strict liability. Now I want to start out by saying this is really important to remember, and people often get confused about it. The elements of strict liability by name are the same as the elements for negligence. Duty, breach, cause and effect, practice, cause, damage. Same thing. But the duty in strict liability becomes a duty to make safe, a duty to ensure safety. If you write in a negligence essay, or you pick in a negligence multiple choice question, that the defendant must assure or ensure plaintiff's safety, you're wrong. And I see that so often. There's a duty to ensure safety. No, it's a duty to use reasonable care in negligence or some variation on it. Oh, I didn't even mention back, we can have a higher standard with like innkeepers, right? And so forth. Higher standard, lower standard, but some kind of standard of behavior. With strict liability, we're saying in this tort, the duty is one to make it safe. You don't make it safe, you're liable, if we have the other requirements. So this is a duty to make it safe for foreseeable people again. The duty gets breached, it wasn't safe. Doesn't matter how much care the defendant used, irrelevant, it wasn't safe. And because it wasn't safe, that actually caused an injury to person or property, same as in negligence. No intervening, superseding, proximate cause issues are there. So it's the same prima facie case with the one caveat that the duty, the standard of care, is now one to make it safe, to ensure safety, which was not true in negligence. So what is this thing all about? It's about the courts having decided that there were some areas of human behavior, endeavor, that they were going to say, we're not going to make the plaintiff have the burden of showing the defendant was unreasonable. That's a pretty hard thing to do. We're going to say, hey, if the defendant engaged in this kind of activity, and that activity caused harm to someone, the defendant should have to pay. If you're going to keep a pet lion and think, okay, I can keep my pet lion tamed and controlled, if you fail, we don't care why, you should pay. You should take that into account before you decide to keep a pet lion. You will be liable if your pet lion hurts somebody. So, when have the courts extended or decided not to use negligence, but rather a strict liability standard? For purposes of the bar, just a few areas. Number one, animals, sometimes. What kinds of animals is there strict liability for? Non-domesticated animals. Lions, tigers, chimpanzees, and so forth. Right? Chimpanzees, yeah. Interestingly, livestock that are trespassing on somebody's property. Anybody here have any livestock? There are livestock that trespass sometimes. If you go to old Western movies, there'd be big disputes between the fence your cattle in and fence cattle out. Old song, don't fence me in. I'm not going to sing it for you. Song, don't fence me in. Let me have freedom to range And there were wars fought out west over, do you have to fence cattle in or do you have to fence cattle out? Protect the crops by fencing in your crops, or protect the crops by having the people fence their cattle in. Well, the general rule, majority rule in the United States is fence your cattle in. And if your cattle go trespassing on somebody else's property and they damage their crops, you pay strict liability. So non-domesticated animals, livestock, trespassing, and abnormally dangerous dogs. So you know that your dog has a tendency to bite people, it now becomes strict liability because you're on notice of that dangerous propensity. That's kind of where the new area where the law is settled on strict liability relatively recently. Number two, so we have animals, sometimes, strict liability. 2, abnormally dangerous activities. Listen to that. Abnormally dangerous activities. That's not abnormally dangerous materials, although it often involves dangerous materials. It's abnormally dangerous activities. So if the plaintiff can show that the defendant was engaged in an activity that's an abnormally dangerous one, then strict liability applies. Test: is the activity one that creates a serious risk to other people or their property? No matter how careful you are, you're creating a serious risk. And it's unusual in the location. It's out of place, abnormal. Abnormally dangerous activities, strict liability. Some things are just treated as abnormally dangerous activities. Blasting with dynamite, right? Abnormally dangerous activity. Operating a nuclear power plant, abnormally dangerous activity. Storing compressed chemicals on your property that if they escape will cause harm to your neighbors, abnormally dangerous activity. But other times you just have to apply the test and ask, well, will the court find this to be an abnormally dangerous activity or not? So we have animals, abnormally dangerous activities, and the third one is product liability if we choose to use strict liability theory with products, but it's going to turn out we can use lots of different theories. So product liability, we can use strict liability. That's it. 3 areas of strict liability: animals, abnormally dangerous activities, products, if we choose that theory. Prima facie case, same as negligence, except we require duty to ensure safety. And now, that is our torts by fault level, which, as I said, is most of the law of torts. Let's look briefly at what I've labeled as the miscellaneous groups of torts. Products, for example, which, were you to open Barbry's table of contents, liability without fault is page 73. Observe, I moved some stuff around in terms of what I'm suggesting you save the defamation stuff for later, but otherwise I'm following the order that Barbry has stuff in. So we have strict liability, pages 73 to 76. Not very long. But then we have products liability as what they call their chapter 5. And under product liability, they say, well, we need a defect. And then, if you turn the table of contents over, and this is something I'm going to have up on the screen for you 30 times between now and the bar. So this is time number 1. I don't have it to put up on the screen. But notice in the outline, liability based on intent. Never happens. Liability based on negligence. Liability based on strict tort liability. Implied warranties of merchantability and fitness. The point about product liability is there's no one fault level. The key is we're talking about any case in which a plaintiff or potential plaintiff is injured by a defective product. We have this whole area. What can the plaintiff do? Well, first, the plaintiff must establish that the injury was caused by a defective product for any of these theories. And a product can be defective in any of 3 ways, and you want to understand them and read them carefully. 3 ways product can be defective: manufacturing defect, design defect, lack of an adequate warning. Design, manufacturing, lack of adequate warning. and learn what those mean, what they would look like in facts. If we have a product that's defective for product liability, we also need a defendant who is a commercial supplier of said product. That could be a manufacturer of a product, a manufacturer of a component part that went into a product, a regional distributor, a local distributor, a retail store, anybody in the chain of supply. As long as the product was defective at the time it left that person's hands and remained defective until it caused the injury, didn't change its condition substantially, then everybody in that chain of supply is liable. So if we take a case that may or may not be memorable to you guys at this point, the Asahi case, which is in CivPro books regularly, defective tire valve stem made in Japan, as I recall, shipped to Taiwan where it's installed in a tire. Tire is put on a motorcycle, different company. They ship this to California, different company. Retailer sells it to motorcyclist. Motorcyclist buys it, rides on it, gets into an accident caused by defect in tire valve stem. If defect in tire valve stem caused the injury, who's liable? Everybody. Because the maker of the tire valve stem sold a defective tire valve stem to someone who put it into a tire, to someone who put the tire on a motorcycle, to someone who sold the motorcycle to someone in California, all the way down. There might be 10 people, 10 companies before we get to the person who actually gets injured. Every one of them is liable, strict liability in tort, as a commercial supplier of a product that was defective and unreasonably dangerous at the time it left that person's hands. I can sue any or all of them. I don't care who pays me or my client. They can seek indemnity, which you've heard of, right? Going back up to the original person. So if I sue the retailer, yes, they're liable, even though they had no way to know that the tire valve stem was defective. They sold a defective product. The retailer can sue the wholesaler, can sue the manufacturer, can all the way back up the line. The ultimate liability should be on Asahi, the manufacturer of the tire valve stem. Right? But it goes back up. So defective product, commercial supplier of that product, and causes injury. Then, what torts can we use specifically for this product? Well, in theory, one could have an intentional product liability case. I know with substantial certainty that this product that I'm selling is defective, but damn it, I need to make a profit. You know, I need to make a living, so I'm going to sell this damn defective thing, knowing with substantial certainty it's going to blow up. I haven't seen the case, but it could be, right? Could have an intentional product liability case. But common negligence, strict liability in tort, breach of warranties under the UCC, implied warranty, express warranty, misrepresentation, a whole bunch of theories. So when you see a defective product, don't just assume that it's got to be strict liability. It can be any of those theories. Big difference. In negligence, even in products, the plaintiff must prove that the defendant knew or should have known by the exercise of reasonable care that the product was defective and unreasonably dangerous. You're representing the plaintiff. How do you prove that the defendant knew or should have known? Well, you go for discovery and you hope you stumble upon something, right? It's very hard to prove that the defendant knew or should have known of the defect. But if you can, you got negligence. But if you can't, that's why strict liability in tort evolved. If you can't prove the defendant knew or should have known, it doesn't matter because you can get them strict liability in tort because they sold a defective product. But alternatively, you still have the theories that we have. Here in tort, we're using theories that come over to us from the UCC. UCC says that a seller of goods makes an implied warranty of merchantability, which may very well be breached here, or the seller of the product may make an express warranty, or the seller of the product may make an implied warranty of fitness for a particular purpose. See the UCC on all of these. But if we breach one of these warranties and cause personal injury, that's also product liability. Or misrepresentation, also product liability. So you're going to have, as I said, you're going to have almost half the questions you have in torts on the MBE are going to be on negligence. But intentional torts and strict liability products, particularly products, are right behind. You combine those and you've got a very substantial number of questions, a very substantial portion of the questions. And that's true in Connecticut, that's true in Massachusetts, that's true everywhere, pretty much, right? Negligence is the most, intentional torts and various strict liability torts, but particularly products. California, whoever's doing California, products, they're obsessed with it, they love it. But other states like it too, okay? So that's products. Next, I'm going to discuss very briefly nuisance. Two kinds of nuisance, private nuisance and public nuisance. What they have in common is basically the word nuisance. Other than that, they're totally different things, right? Private nuisance, which is tested all the time. I feel comfortable saying you will have, in high degree of probability, one or two MBE questions. Anything that's almost always there, one or two questions, is important. Private nuisance is something they test regularly, and it can be done property or torts, same thing. Plaintiff must prove that the defendant substantially and unreasonably interfered with the plaintiff's use and enjoyment of real property. This is right in your outline, okay? Substantially and unreasonably interfered with use and enjoyment of property. Well, why isn't that just negligence? Well, number one, it's use and enjoyment of property, so the damages would not be enough for negligence. And number two, the unreasonableness here is treated differently than in negligence. If I know that operating my cement plant, a case that might ring a bell with some of you, Boomer versus the Atlantic Cement Company, I've built a cement plant. I know that my cement plant is going to pour out particulate matter over all my neighbors for a mile in every direction. There's nothing I can do to prevent it. Can't prevent it. And it's going to strip the paint off their cars and strip the mucus linings in their lungs, and so what? The cost and value of my cement plant is going to be more than the injury to them, so it's not unreasonable, so it's not negligence. That would be the argument. But to impose on your neighbors that you're doing something that's going to strip the paint off their cars and their houses and the mucus linings off their lungs is an unreasonable thing to impose on your neighbors. So we just look at that part of unreasonableness and say, yeah, that's going to be a nuisance. Going to be tested all the time. Question or two, private nuisance. Public nuisance. It just shares the word nuisance. Otherwise, it's a totally different thing. It's when a person, defendant, is doing something that's injurious to public health, safety, welfare. Could be pouring out particulates from their cement plant, whatever, but the person bringing the case, if it's a public nuisance, the public's being injured, the suit ought to be by someone representing the public, not a private tort suit. When can a private person, an individual, bring a suit based on you, defendant, committed a public nuisance? If, but only if, the particular plaintiff can say, I was injured in some way distinct from the injury to the general public. I suffered an unusual and serious personal injury. Public nuisance. Fairly big area of testing on both MBE and fairly often on essays. Defamation. Less so invasion of privacy, but that stuff that was earlier in the Barbary outline, I'm saying put it back here with the miscellaneous torts. defamation always tested generally a couple of questions on the MBE, 2, maybe 3 questions on the MBE. In defamation, plaintiff must prove that the defendant made a defamatory statement of or concerning the plaintiff, that it was published, whatever that means, and that it caused damages according to various rules. End of the common law. Along cometh the Supreme Court of the United States. Along cometh a defendant who says, wait a second, Your Honor, if defamation can be used in a case like this and damages can be given by a jury, then we're going to have to shut down the New York Times, the Wall Street Journal, NBC, ABC, Fox, and everybody else, because we make statements and people get offended and they sometimes may injure their reputation and juries may hate us and they may give big damages against us. And aren't we supposed to have freedom of speech? And somehow or other, this never came up before the 1960s or so, when it came up in the famous case of New York Times against Sullivan. You don't need the case name, but some of you may have heard of it. And the Supreme Court said, you know, we have to take the common law of torts and we have to consider what the effect of the First Amendment on that is. And in order to protect the interest in free speech, we have to let people do things that we might otherwise wish they didn't do. Make disgusting films tearing apart other religions. Right? Freedom of speech. So, what are we talking about here? We're talking about how the First Amendment impacts that common law tort of defamation, and the Supreme Court determined over time, this is like a doctrine that's evolved over 40-some years, 50 years now, that if the plaintiff is a public official, Obama, John Boehner, or the plaintiff is a public figure, a person who exposes himself or herself to the public, Janet Jackson. Nobody? Cher. Person who exposes themselves to the public widely, then they have a special burden. We say if the plaintiff is in a certain class of people and they're suing for injury to their reputation, they have a harder burden of proof because we want to protect the speech of the defendant, and the plaintiff, after all, is someone who's out there in the public limelight and has access to the press and so forth. So we're going to say plaintiff has 2 additional burdens. Going to make it harder for the plaintiff to win a suit against the New York Times or against the National Enquirer, for that matter. We're going to say that the public official or public figure plaintiff must prove 2 additional elements, and those are falsity and fault. Hey, Rich, you mean to say that the plaintiff didn't have to prove that the statement was false in defamation? That's right. The burden was on the defendant to prove truth as a defense, right? But now New York Times against Sullivan says we put the burden on the plaintiff in these public official, public figure cases to prove that the statement was false. Extra burden of proof. But maybe more important, we say you need a fault level. You can't just prove they made this defamatory statement. You have to prove they made it with malice. What's malice mean? It means either knowing the statement was false, or with something that's going to sound familiar to you, with reckless disregard of whether it was true or false. I know the statement is false, I'm going to publish it anyway. Ha ha ha. Or, I have reason to believe the statement is false, I know there's a really good possibility and I don't care, and I publish it. Knowing it's false or reckless disregard, those are the additional burdens. So the statement must be defamatory, must injure a person's reputation, must be about the person. We have to prove that it's about that person, and sometimes, it might be unclear how do we infer that it's about that person. Has to be published, which means communicated either intentionally or negligently to a third person. How can you communicate intentionally to a third person? Easy. let me tell you, Jones is a thief. That's intentional communication to a third person. I hope your name isn't Jones, right? Okay, Jones is a thief. But how can I negligently communicate to a third person? I have Jones in my office, door is closed, walls are thin, and I say, Jones, you're a thief! And I say it very loudly so that it can be heard beyond the walls. So I'm negligently allowing third persons to hear it. Communicated, published to a third person. And then lots of interesting little damage rules, which I just send you to your Barbary outline to read. And lots of defenses, which I send you to your Barbary outline to read. Consent is a defense. Sometimes one might consent to having someone speak what might be defamatory, in which case you got a defense. Truth, a common law, was a defense. Privilege is a defense, and privileges can be, see the details, either absolute privileges or qualified privileges, but they are defenses. And I skipped one thing. Let me go back to the plaintiff's case. If the plaintiff is a public official or a public figure, I said they've got to prove falsity plus malice, right? What if the plaintiff is not a public official or a public figure, but rather a mere private person, but they're involved in a matter of public concern? They voluntarily go out and say, hey, I want to go on your TV show and talk about this because I'm concerned. They get involved in a matter of public concern, but they're not a public official or a public figure. Well, the Supreme said, well, those persons must prove falsity and at least negligence. They don't have to prove malice, but just falsity and negligence. So when would we ever apply just the common law 4 elements? Only if the defamation is a defamatory statement about a private person and about a matter that is not of public concern. John Jones, the bartender at a local bar, is a thief. Probably not a matter of public concern. Okay, then just the common law. A couple of questions on defamation. Heavy essay testing appears very often as an essay issue in California, fairly often in other states. Invasion of privacy appears very rarely on both occasionally on MBE and fairly rarely on essays. 4 different theories of invasion of privacy. Study the 4 different theories, but don't expect a lot of questions. And then there's some more miscellaneous type torts. They're torts involving misuse of the legal processes, abuse of process. I'm using a legal process not for its real purpose, but to harass someone. Malicious prosecution. I initiated prosecution against someone, and I don't have probable cause to believe they did that crime, and then they wind up getting found not guilty. I can be sued for malicious prosecution, which is different from abuse of process. Various kinds of interferences. None of them tested a lot, but appear. Interference, malicious interference with business relations. Intentional or malicious interference with family relations. Interference with future contractual relations, and so forth. Very seldom tested, but they appear, so you want to be aware of them. Okay? That's it. We have our torts by fault level, intentional torts, negligence, strict liability. We have our miscellaneous torts, products with lots of different theories, nuisance, public and private, defamation with its constitutional aspects, invasion of privacy, a series of other little torts having to do with legal process or interference with business or family. We're done. That's it, except those things that I referred to as the general doctrines that apply widely through the law of torts. And they're so easy to miss in a fact pattern, you don't want to miss them. And there's some states, some people are doing Massachusetts, right? Massachusetts? Hands high? Yeah. Massachusetts, it doesn't make any difference because they're all graded on a curve, but Massachusetts gives some of the nastiest essays ever. California gives the easiest essays in the world, except for Colorado's, which are even easy, just really easy. Massachusetts will take what would be in a Connecticut tough essay and double the number of issues and give you 6 more minutes to do it, basically. The thing about Massachusetts, I don't want to pick on any of my former colleagues here, so I won't mention Professor Meyer, who is a brilliant, wonderful person I adore and love. I don't know, maybe she, or Feigenson for that matter. They give torts exams with 50 plaintiffs and 49 defendants, and you got 1 hour to figure out all the torts involved. Anybody have that kind of test from one of them? Yeah. And Feigenson, I don't know, he's a wonderful guy, but his answers, he used to 50 pages single-spaced for a 1 hour question. Okay, I can't type 50 pages in 1 hour, single-spaced, let alone think all those thoughts. Right, well, Massachusetts must have, those people are writing their essays because they'll have, for a 36-minute, you have 36 minutes to do Massachusetts essays, and they'll have 6 or 8 or 9 plaintiffs and 6 or 8 or 9 defendants and so much going on. But there's a way to deal with that kind of thing, and we'll talk about that. Well, you know, Connecticut doesn't do that. New York doesn't do that. California doesn't do that. Massachusetts does. New Jersey, to some extent, does. You just have to approach them differently, right? And one of the things these general doctrines are often there in Massachusetts, and they want you to catch them. They're not as often in other states, but they may be. When I refer to general doctrines, these are things that apply widely through a bunch of different tort areas. And one of them is the general question, when will one person be liable for somebody else's torts? That's the whole course in agency, right? But it's tied into torts, or it's part of half the course in agency. When is one person going to be liable for somebody else's torts? I didn't do the tort, but my employee, my agent, somebody did the tort. I can or cannot be liable. When? 2 general concepts. Number 1, if it's an employment relationship, the employer or master is liable for any tort committed by his or her employee that's within the scope of the employment relationship. That's a paragraph. The title of the paragraph is vicarious liability, or respondeat superior. The rule that you would plug in is employer is liable for the torts of employees within the scope. Then you apply, is this person within the scope, blah, blah, blah. You get a point that you otherwise wouldn't get. So that's respondeat superior where there's an employment relationship. But what if there is not an employment relationship between the defendant and the tortfeasor, but rather a relationship known as the relationship of being an independent contractor? I hire someone not as an employee, but as an independent contractor. I don't control how they're going to do the job. Now I'm not liable for all the torts of my independent contractor, but I'm liable 3 different theories, and this is tested every test. I'm liable for torts of my independent contractor if one of 3 things is true. Number 1, I was negligent in selecting my independent contractor, in which case it's really my own negligence. I needed work done on my electrical system in my home. I went to 3 contractors, and one said, yeah, that's a big job, $20,000. Second said, it's a big job, I'll give you a little discount, $19,000. Third person was a struggling law student trying to pay tuition and get through, and said, I'll do the job for $1,500. I'm really desperate. Said, I can pay $20,000, $19,000, or $1,500 for the same job. I'll go with $1,500. I don't bother to say, by the way, do you know what you're doing? No, I've never done it. I don't check, right? I'm on notice the person doesn't really know. Then I'm liable for my negligence in selecting. I'm liable for what they do. But there are 2 other ways that we can be liable for torts of an independent contractor. And one is if the independent contractor is engaged in something that the law treats as a non-delegable duty, whatever that means. Usually they're going to tell you in the question, this was a non-delegable duty under the laws of the jurisdiction. Sometimes you're expected to know that it probably is a non-delegable duty. Let me tie several areas of this discussion together. Suppose I am a food store, Lipfin's food store. I have a duty to my invitees to maintain the place and to inspect the place. I hire Christina's service to fix something. She does it negligently. I'm liable. Because I can't delegate my duty to protect my invitees. That's a non-delegable duty. Even if I hire an outside person, I'm still liable because it's a non-delegable duty. But generally, they're going to have to tell you it's a non-delegable duty. So either I'm negligent selecting my contractor, it's a non-delegable duty under the laws of the jurisdiction, I'm liable. The third area of liability is cute. Remember we had abnormally dangerous activities a while back? Well, I'm liable for the torts of my independent contractor if the contractor is engaged in a hazardous activity. Not really clearly defined, but if they're engaged in a hazardous activity, which is often going to be an abnormally dangerous thing like blasting, but if they're engaged in a hazardous activity, I'm liable for the torts of my independent contractor. 3 ways. Be aware of them. Okay? So liability of an employer for employee, liability of a person who hires an independent contractor, always tested on the MBE for at least one question, often essay issues. They love the independent contractor thing on the MBE because it's so complicated. Second, as opposed to when can one person be liable for somebody else's tort, what if there are multiple defendants, each of whom is liable? So I've got a judgment against A, B, and C. What's the relationship between A, B, and C as to that liability? Can they shift liability from one to the other? Doctrine's called contribution, not called contributory negligence, called contribution between joint tortfeasors, or indemnity. And what's the difference? And when can one tortfeasor get indemnified by another tortfeasor? And when can one tortfeasor get contribution from another joint tortfeasor? Read that material in Barbary carefully. It will be tested. When for indemnity, when for contribution. Okay? Third, what happens if a person who is injured dies? At common law, that was the end of the matter. Strange, but anyway, in modern law, we have wrongful death and survival available. Survival means that even though the person is dead, his cause of action survives him, and the estate owns it and can enforce the suit for negligence or battery or whatever. His action survives, and the damages to him can be collected by his estate. Survival. Wrongful death, persons in certain familial relations who had expectations of being provided for by the deceased person can say, you wrongfully killed my father. I was expecting support from him, my husband, my whatever. So wrongful death and survival, you need to just be aware of what they are. Fourth, sometimes there's something about a party that leads to that party getting immunity from being sued. Governments sometimes have immunity for certain things. Charities used to have immunities very broadly, now have much less in the way of immunities. Inside of families, people inside of families suing each other for torts. Used to be a lot of immunity, now there's still some immunity, but a lot less than there used to be. Those are the things that you're looking for in the general considerations. It's going to be a few questions on every exam, maybe 3 or 4, maybe 5. Not a huge number. When's one person liable for torts of another? Respondeat superior, independent contractor. If we have multiple defendants, can they shift liability between among them, contribution and indemnity? Skipping. Oh yeah. What happens if a party has died? Survival, wrongful death. And finally, tort immunities. Not a big deal, but you need to be aware of it. That's the whole law of torts. I don't know how long I've been talking. Probably about 2 hours, right? Something like that. So a lot shorter than the Barbary lecture, which will be more like 8 hours and go into some more detail on things. My goal is not to even pretend that I'm covering every detail that might be there, but I covered a fair number of the details. Now I've given you a basis for reading the outline more intelligently. I want you, when you go to read the outline, to study the table of contents because it lays out a little bit more detail. I want you to think about annotating your own table of contents very neatly, because if you do it, you can be stuck with it, probably do it in pencil, but you might put in here, oh, that was question 1, that was essay number 3, little cross-references to stuff that we do in class, but also next to the torts. Barbary doesn't always, or often they don't lay out the prima facie case, so in the table of contents you can write next to battery, voluntary act intended to cause and causing harmful or offensive conduct, so that every time you look at that tort, you're seeing there in your own print that you're reviewing the prima facie case. You will get slides from me with the prima facie cases for all the torts as we discuss them every time they come up, pretty much every time they come up on the screen on my DVDs is going to go in battery plaintiff must prove. So you're going to see them over and over and over again. You will remember them because you will see them, you will hear them, you will write them, you will apply them, and you'll do it again until they are second nature. But I think it helps to write them in the table of contents. When you read the outline, if you're not just reading one rule after another rule, but you know where you are, okay, I'm spending an hour and a half on the intentional torts, person, property, defenses. I've got a structure. I've got file cabinets and drawers, and I know where I'm putting things. Number 1, it makes it easier to remember them. Number 2, it makes it easier to use them and apply them. And then in the margins, again, you can do these little cross-references, conversion, see the sales outline, trespass, see nuisance, and so forth. Keep them small and neat because as we go along over those 7 or 8 classes on torts, there are going to be all sorts of little cross-references you want to make.